everyone. Welcome to School's Law. It's Salawat, and today we are going to be talking about Promissory Estoppel under contract law. In our last video on contract law, we talked about consideration, and a very connected concept to the doctrine of consideration is the doctrine of Promissory Estoppel. In English, when we say you are stopped from doing something, it means that you've been prevented from doing something. Promissory estoppel is that common law doctrine or common law principle that prevents a promisor from going back on his promise not to insist on his strict legal rights under a contract. Now, that may be a little bit confusing, but then here is the thing. When there is an existing contract, both parties have certain rights and obligations. Sometimes one of the parties may promise not to enforce on one or more of those rights. The doctrine of promissory estoppel prevents the person who has made that promise, the promisor, from going back on the promise if the promisee has relied on that promise and has acted on it to his detriment. It was first established in the case of Hughes versus Metropolitan Railway in 1887. In that case, the claimant was the owner of a property that had been leased to the defendants. And as part of the terms of the lease agreement, they were supposed to conduct repairs on the property within 6 months of notice. After the notice was given, but before that 6-month period elapsed or reached, the defendants sent a letter to the claimant asking him to purchase the leasehold interest on the property. They began negotiations, but the negotiations were not successful. Now, after the negotiations fell off, the claimant said that they had 6 months from the original notice. This became a banter between the two of them, the defendant and the claimant, because the defendant said that they had 6 months from the date the negotiation fell off. The courts held that the opening of negotiations by the landlord implied a promise not to insist on his legal rights strictly as to the time or the date the notice should take effect. And the defendant in this case had acted on that promise to their detriment. And so he was stopped from going back on it. Therefore, the court held that he had given them 6 months, or the defendant had 6 months from the date the negotiations fell off. In this case, the court implied a promise not to insist on his strict legal rights as the landlord. But there are more direct cases where the court isn't making an implication, but the promisor has explicitly stated that he's not going to insist on his rights, or has explicitly communicated that he's not going to insist on his rights. Whether it is by implication or it is done expressly, where there has been that promise that you are not going to insist on your legal rights under a contract, and the other party relies on it to their detriment, the promisor is stopped by the doctrine of promissory estoppel from going back to it. And a case that shows how sometimes some of these promises are express or direct is the case called the High Trees case. And in that case, the parties had agreed on the reduction of the amount to be paid as rent for a property that was leased, because there was an ongoing war. As a result of that, the economy wasn't doing too well, so it was difficult to extract the profits on the property. But when the war ended and the economy recovered, the plaintiff, was the landlord, insisted on going back to the original rent as agreed between the parties. The defendants claimed that the plaintiff was stopped from going back on the original price or the original rent as agreed between them. The court said that in this particular case, it seems to have been that the parties agreed that the reduction was only be effective during the time of the war, or during the time when the economy was in recession. And so, considering that those conditions under which the promise was made were no longer standing, the circumstances were ripe for the parties to go back to their original positions. So you see that in this case, the only reason why the doctrine of promissory estoppel didn't apply was because the court made an implication that under the circumstances, the parties agreed that the claimant, who was the landlord, was not going to insist on the original price or on the original rent because of the times. Now, since those times are no longer, the case, then it should be possible for the parties to go back to the original price. But the high trees case also tells you how parties may have an express agreement, or the promissor may make an express promise not to insist on a certain right he has. In this case, the right being the right to charge the original price as agreed. In Hughes versus Metropolitan Railway, you see that the court made an implication that by conducting himself in a certain type of way, the landlord had intimated that he was not going to insist on the date the notice should take effect. The High Trees case also tells us that the doctrine of promissory estoppel is not absolute. What that means is that it is very possible for parties to go back to the original positions under the contract. It is very possible for a promissor to want to go back to insist on his rights under a contract, even though initially he had agreed that he was not going to. In Ajayi versus R.T. Briscoe, the Privy Council held that the promissor can only go back on his promise not to insist on his strict legal right if it is possible for the promisee to go back to the position that he was in before the promise by the promissor. If that is possible, then the promissor must give the promisee time to go back to that position before returning to insist on his strict legal right. Therefore, the promissory estoppel, or the doctrine of promissory estoppel, is only irrevocable if it is not possible for the promisee to go back to the position that he was in before the promise. Remember that the parties have already made an agreement. And so the moment one of them promises not to insist on any of his rights under the contract, it affects the position of the other party under the contract. And so for the party who made such promise, the promissor, to be able to go back and insist on his right or go back on that promise, then the party who relied on that promise must have the opportunity to go back to the position that he would have been in had it not been for the promise by the promissor. This is where we end today's video. Thank you so much for watching. Just by way of summary, remember that the doctrine of promissory estoppel is the doctrine at common law that prevents a promissor from insisting on his strict legal rights after he has made a promise not to, and the promisee has relied on that promise to his detriment. The locus classicus is the case of Hughes versus Metropolitan Railway. You can also read the High Trees case and the case of Combe versus Combe. Thank you so much for watching. Bye.